Hi everyone, my name is Patrick Schumann. I'm a counsel in Reed Smith's Restructuring and Insolvency practice in London. And today we'll be talking about the temporary measures introduced by CIGA. Yeah, that's absolutely right. So the UK government originally introduced, by way of background, a series of temporary measures last year under the Corporate Insolvency and Governance Act 2020 to give businesses breathing space during the pandemic. After a number of extensions, the measures were expected to expire on 30 June 21. However, given that the government postponed the complete lifting of COVID lockdown restrictions, there was a concern that businesses were still under pressure and that a removal of the temporary measures would come too early and potentially result in a wave of insolvencies, which of course these measures were intended to avoid. So what are the details of the latest extensions? The restrictions on statutory demands and winding up petitions for COVID-19 related debts has been extended for a further 3 months until 30 September 21. And the prohibition on commercial landlords forfeiting leases for non-payment of rent and on the use of commercial rent arrears recovery will be extended for a further 9 months to 25 March 22. However, certain insolvency measures have not been extended, including the relaxation of directors' liability for wrongful trading, which will end to 30 June 21, and the relaxation of some of the requirements for entering into the new CIGA moratorium will end on 30 September 21, as originally intended. That's right. The aim of this new piece of legislation is to find a way for landlords and tenants to share the pain. Unpaid rent that has built up when a business has had to remain closed during the pandemic will be ring-fenced under the new rules. The legislation aims to help tenants and landlords work together to come to an agreement on the terms of a repayment plan. Where an agreement cannot be reached, a binding arbitration process will enable both parties to come to a legally binding arrangement. Yes, they certainly are. According to the Insolvency Service, compulsory liquidations are down more than 85% compared to the same period in 2019. And it's a similar picture for the other types of insolvency proceedings. The restrictions on statutory demands and winding up petitions in particular have had a marked effect in suppressing the natural cycle of insolvencies. This is because a creditor may not, at the moment, petition for the winding up of a company unless coronavirus has not had a financial effect, or the company would have been unable to pay its debts, even if coronavirus had not had a financial effect on the company. And this is evidently a real challenge for creditors to prove, because it is only necessary for the company to establish a prima facie case that coronavirus has had a financial effect. In most cases, creditors simply do not have access to sufficient information to refute such a position. Well, the big question is whether the temporary measures will truly help businesses survive the pandemic, or whether they merely postpone the inevitable by pushing out the insolvency wave. In the meantime, creditors and in particular landlords bear the burden of these measures. The jury is still out there as to whether the right balance has been achieved. We can expect some indication as to how this might play out and when the first measures expire, i.e. at the end of September. So watch this space.